lord, I have already been.
You have already cured?
My lord, court fees has already been paid. But
And
still,
there is court fees again. वकालतनामा वगैरह सबका हो गया है?
my lord, I have paid the court fees of 70 rupees, lordship.
70?
Lordship 20.
हाँ ठीक है, 25,
and
25, 20. Right, right, right. sir. बताएं सर.
Lordship, petitioner is a registered owner of the plot number 19A, area 15/30, 450 square feet, which is situated at the Subhas Colony, Gram Simra Kala, Tehsil Hujur, District Bhopal, Lordship. Applicant purchased the said plot, Lordship, in year 2006. Document is annexed, Annexure A2, page number 16. Respondent number 2, Lordship, in year 2000.
You are in possession of, you owner of 19A.
Lordship.
Respondent is owner of 20A.
Lordship. There is a dispute regarding the.
Now his allegation is that somebody has encroached upon 20A.
20A, Lordship. Lordship, earlier 2 round, Lordship, the matter.
अब क्या finding क्या है इसका?
Lordship, as per the impugned order, Lordship, earlier 2 occasions, Lordship, the order has been passed against me, and when I have.
Fine, पुराने वाले तो छोड़ दें.
My lord.
अभी का SDO का last final order कौन सा है?
Annexure A1, Lordship.
That is the past by. नहीं, ये तो वैसे हमारे regional court का है.
SDO passed the order, Lordship, which is A5, Lordship. Page number 40, Annexure A5. Order of the SDO and order of the revisional court is which is under challenge is Annexure A1. Against the Annexure A5, Lordship, I have applicant preferred the revision before the court below, Lordship. That is also be dismissed and upon the order passed by the SDO.
Possession कब किया? Encroachment कब किया sir? चौधरी sir?
Lordship, as per the applicant, Lordship, he purchased the land in year 2006 and thereafter he having the.
No. This 145 application was filed by the police or by the respondent?
Respondent, Lordship.
By the. तो चौधरी साहब, इन्होंने कब्जा कब किया?
So in fact, Lord, I have called for record of the matter, my lord. I have called for the record of the matter because there are.
अरे वो ठीक है.
जी जी.
आप तो मुझे बताइए कब्जा कब किया सर?
There are various orders, my lord, which are required to be brought on record. Certainly.
Whatever it is. आप तो ये बताइए कि आपने के हिसाब से कब्जा कब हुआ? आपकी एप्लीकेशन है आपके पास 145 की?
That I have called for, my lord. Copy of the petition is also not.
I don't know, sir.
My lord.
You have entered your appearance.
My lord.
है ना? What is the finding by the SDO or SDM, whatever it is?
Lordship, that is an excerpt. Lordship, that is an excerpt A5, Lordship, page number 40.
So what is the finding that on what day the encroachment was done, sir? बस इतना है, 19A की आड़ में 20A पे कब्जा किया हुआ है. कब किया है एसडीएम साहब ने कुछ नहीं लिखा.
That is silent, Lordship.
आप बस दोनों ऑर्डर्स देखिएगा, मुझे और कुछ नहीं चाहिए। हमारे एसडीएम साहब ने कब लिखा है, क्या लिखा है कि कब कब्जा हुआ,
That is
और हमारे रिविजनल कोर्ट ने क्या लिखा है, बस इतना बताइए। और अगर ये फाइंडिंग नहीं है
नहीं
तो
है
फिर तो कुछ नहीं हो सकता चौधरी साहब, ये सिविल सूट थोड़े है।
The undertaking which has been given on the part of the petitioner.
Whatever the undertaking might be, 145 requires the restoration of the possession if it was taken 2 months
2 months, my
prior
lord,
to the
that's
date of the report. That is all.
Sir, could it be taken faster than that?
सर आज पता नहीं आप लोग पास ओवर में आ पाएंगे कि नहीं आ
Or
पाएंगे।
it could be taken tomorrow top of the list.
ना ना छोड़िए उसको, आप तो बस इसमें आराम से करिए। आज तो वैसे भी आप बहुत ज्यादा अपीयरेंस होनी नहीं है, तो आई एम ऑल्सो नॉट इन अ हरी। आई एम ऑल्सो नॉट इन अ हरी। Today it is a day of celebration for the lawyers, sir. Let them celebrate, no problem.
My respectful submission in that regard is there's various proceedings which has been done.
Sir, whatever it may be, there has to be a finding in the final order, right? So once the previous orders of the SDM were set aside and the matter was remanded back, whether the final order is required containing all the necessary ingredients or one or two ingredients are sufficient. Dispossession, encroachment, fine, no difficulty. But in order to maintain an application under 145, it has to be within 2 months of prior to the date of the application by the, or information by the police. That is all. It is not a civil suit.
No.
And I think that SDM has decided like a civil court.
my lord. A4, हाँ प्लीज A5 रिविजनल कोर्ट का ऑर्डर ये है, इसमें कहीं नहीं है। My lord, there is no.
I've seen there is nothing, neither in the order of the SDO nor in the order of the revisional court. Both the courts have decided the proceeding as if that they are the civil suits.
The evidence which were recorded before.
I am not concerned about evidence, I am concerned about the findings. If you think that there is an evidence, Chaudhary sir, I have two options. If you think that there is already an evidence, I can remand the matter. Right? कि भाई ये फाइंडिंग ही नहीं है इस पे ऊपर, और अगर एविडेंस नहीं है तो मैं अभी नया फ्रेश एविडेंस रिकॉर्ड करने के लिए रिमांड नहीं करूँगा. I will remand just to reassess the evidence and give a finding whether Is there anything on record that on what date the respondent was dispossessed? And if there is no evidence at all in this regard, then the parties are free to approach the civil court. We cannot convert section 145 into a regular civil suit under section 9 of CPC, sir.
For that, the record is bulky, my lord. That's why I'm
No
saying
problem, no
we
problem,
can
sir.
pass over around it.
चौधरी साहब मैं आपसे कहूँ कि आपका जो भी एविडेंस हो,
जी।
I am not commenting upon that. I am commenting upon the order passed by the SDM. I am not saying that you did not lead any evidence at all.
No.
What I am saying that if evidence was on record, then it was it not necessary on the part of the SDM to appreciate it and to then to come to a conclusion. SDM could have said no, he was dispossessed prior to 2 months. He could have said no, within 2 months. But unless and until you appreciate the evidence, how the order can be upheld? और 2 बार रिमांड हुआ है, एसडीएम साहब को अभी भी होश नहीं आया. How such type of orders are being passed, sir? As if that SDM has become a civil court. 48427 of the 2023. This application under section 482 of CRPC has been filed seeking the following case. In view of the controversy involved in the present case, it is not necessary to refer to the facts and evidence in detail. It is suffice to mention here that the police filed an application under section 145 of CRPC on the allegation that the petitioner is in possession of plot number 19A, whereas the respondent is in possession of plot number 20A, and the petitioner has encroached upon a part of plot number 20A. On 2 occasions, the matter was remanded back because the revisional court found certain inherent lapses in the proceedings conducted by the SDO. On the 3rd occasion, the SDO, after
permits me.
SDM, I guess, junior, Hanji.
Both the it is before the SDM court that both the parties were claiming possession.
Sir चौधरी साहब, जब कोई भी केस कंटेस्ट होता है तो क्लेम काउंटर क्लेम चलते हैं. काउंटर क्लेम वो स्ट्रिक्ट सेंस में नहीं. जी जी. आपने कहा यस, इन्होंने कहा नो. जी. Then it is for the trial court to consider both the evidences and then come to a conclusion. मैं बार बार कह रहा हूं कि I am not saying that you did not lead any evidence. No. What I am proposing is to remand the matter to reassess this finding, to give this finding that whether there is any evidence to show that you were dispossessed within 2 months from the date of the information. If there is no evidence, then nothing can be done, then the party should be relegated back to the civil court. I am leaving it to the SDM only. I also know that the record is not before me, so why should I give any finding either this way or that way, sir? SDM, after reproducing the provisions of section 145 of CRPC, held that it is necessary to see that who was in possession, who was forcibly and wrongfully dispossessed within 2 months next before the date on which the report of a police officer or another information was received by the magistrate. However, surprisingly, did not touch this aspect and simply gave a finding that the the applicant has encroached upon some part of plot number 20 dash capital A of capital A. Even the revisional court did not touch this aspect. And it appears that the proceedings under section 145 of CRPC have been decided like that of a civil suit. The mandatory requirement to initiate proceedings under section 145 of CRPC is that the SDM must give a finding that who was illegally or forcibly dispossessed within 2 months next before the date on which the report of a police officer or information was received by the magistrate. In absence of such a finding, no proceedings, no final order under section 145 of the RPC can be passed, directing one of the party to revert back the possession. But since the record of the court below is not available before this court, it's not available. Therefore, it is difficult for this court to give a finding as to whether the respondent had successfully pleaded and proved that he was forcefully dispossessed within 2 months next before the date on which the information was given by the police or not. Therefore, the order dated 30/6/2023 passed by Sub-Divisional Magistrate Govindpura Nishatpura Division Bhopal and order dated 12/10/2023 passed by 4th Additional Session Judge Bhopal in Criminal Division number 390/2023 are hereby set aside. The matter is remanded back to the SDM Nishatpura Govindpura Nishatpura Division Bhopal to give a specific finding as to whether the parties have successfully pleaded and proved that as to whether the respondent has successfully pleaded and proved that he was forcibly dispossessed within 2 months next from the date on which the report of a police officer or information by the magistrate was received or not. If the SDM comes to a conclusion that the respondent has failed to prove the aforementioned important aspect, then भैया आपको complaint है ना कि आप
Both the parties have submitted complaint before the concerning court, Manoj.
मेरे
There is application on the part of the petitioner as well.
मेरे भाई, please read out the opening line of the order dated 30/6/A5. और ग्रीवियंस किसको है? आपको है ना?
Both the parties have some disputed.
अरे चौधरी जी यार क्या बातें करने लग जाते हो यार? Merely because you are at the receiving end, that doesn't mean that you should skip the legal provisions. First of all, read out the first line of the order dated 30/6/2023. Who filed the istighatha?
The respondent has filed.
Respondent or state? SHO?
The istighatha was on the part of the state, but
बस वो ठीक है ना? ऐसा आपको रिलीफ चाहिए ना 145 में? On whom the burden lies that he was forcefully dispossessed within 2 months, whether on the applicant कि मैंने इनको 2 हफ्ते 2 महीने के अंदर डिस्पोजेस किया, ये बोले कि आप बोलोगे?
For a moment, the order.
Anyhow, sir, I'm not going to discuss anything more.
एक मिनट मेरे इतना बस निवेदन सुनने. The order which was challenged before the revisional court, that was passed in favor of the petitioner. It was contended that the respondent is in possession, and there it was directed to deliver possession to the respondent against that order.
अच्छा तो फिर ठीक है ना सर, फिर आपको क्या प्रॉब्लम है? अगर आप पोजेशन पे हैं तो मैं अलाउ कर देता हूँ, 2 मिनट में क्वेश्चन कर देता हूँ, मुझे क्या है? चौधरी साहब आप क्या बात कर रहे हो यार? इफ यू उनका कहना है कि मेरा जो पोजेशन है मेरी जमीन के ऊपर है, मेरा 20 पे कुछ भी नहीं है. आपका कहना है कि 19 के अलावा 20 पे भी थोड़ा सा पोजेशन कर लिया है. ये कुछ भी बोले, फाइंडिंग किसको देनी है? कोर्ट को कि मुझे और आपको? अगर ये पहले दिन एडमिट कर लेते कि हाँ मैंने 20 के ऊपर कब्जा किया हुआ है, तो बचता क्या कंटेस्ट करने के लिए? ये तो यही कहेंगे ना, ये 20 में है, मैं 19 में हूं, मैंने कोई किसी पे कब्जा नहीं किया हुआ. अगर आपको लगता है कि कोई डिस्प्यूट नहीं है, मैं सारे क्वेश्चन करके खत्म कर देता हूं. मेरे पास अगर ऑर्डर होता, सॉरी गवाहियां होती, तो आई वुड हैव डिसाइडेड यहीं पे कि भाई वेदर सिविल सूट शुड अप्लाई और 145. ये तो बड़ा अच्छे तरीके निकल आए यार. एसडीओ के यहाँ चले जाइए, 145 की प्रोसीडिंग्स के नाम के ऊपर सिविल सूट डिसाइड करा लीजिए. ये क्या मतलब हुआ? सुप्रीम कोर्ट कह के थक गई कि सिविल केसेस शुड नॉट बी गिवन द क्रिमिनल कलर ऑफ क्रिमिनल केसेस, और यहाँ पे वही धंधा चल रहा है. सो मैं तो इसलिए लिबर्टी दे दी कि भैया आप एविडेंस, एग्जिस्टिंग एविडेंस के ऊपर डिसाइड कीजिए पहले, और अगर नहीं है तो देन स्टे अवे फ्रॉम दिस प्रोसीडिंग्स. दैट इज ऑल.
My lords have ordered that, my lord, if the
I will not grant any opportunity to any of the party to lead
I'm
further
not asking
evidence.
for liberty to adduce evidence, Manoj.
Hmm.
My respectful submission is that both the parties are claiming that they are in possession of the on the dispute.
File a civil suit, sir. Then fine. File a civil suit. क्या लिखा है?
Manoj may remand it.
No, I am not remanding now.
Manoj,
No, sir, sorry. Yeah, thank you.
Manoj,
Neither the SDM, Govindpura, Nishat, oblique
my
Nishatpura,
sincere apology,
Bhopal
Manoj, may kindly be accepted.
has given a finding that the respondent was dispossessed within a period of 2 months next from the date of receipt of information from the police. Nor the revisional court has given such a finding. Initially, this court was thinking of remanding the matter
Manoj, may
back,
kindly consider.
but
My respectful prayer.
But-
Manoj,
in view of the fact that in spite of 2 remands, the SDM has still committed the basic illegality and has assumed the powers of the civil court to decide the 145 proceedings as if they are the proceedings under section 9 of CPC. Accordingly, this court does not find it proper to remand this matter back to the SDM, Govindpura oblique Nishat division, Bhopal. Full stop. The orders dated are hereby set aside. The parties, it is directed that with an observation that if the respondent so desires, then he can approach the civil court for redressal of his grievances.
Manoj, my respectful submission, Manoj, may kindly be remanded.
Right, sir, आप
What is
नहीं
not there, Manoj? There is evidence, Manoj. There is admission on the part of the
मैं
petitioner,
क्या
that's why I am
करूं?
submitting, Manoj.
मैं क्या करूं? ऑर्डर लिखाने से पहले समझा दिया, हिंदी में, अंग्रेजी में, दोनों में. नहीं समझ में आ रहा है, फाइन.
और मैं सिंसियर अपॉलॉजी,
अब जो मुझे समझ में आया मैंने कर दिया.
मैं सिंसियर अपॉलॉजी में kindly-
विजय जी, मैंने आपके हित की सुरक्षा के लिए कहा था कि चलिए अब कोई एविडेंस नहीं.
Right, my interest-
अब आप फिर एविडेंस को तोड़ फोड़ रहे हो.
नहीं, Manoj, my evidence-
What do you mean that he has admitted? Yes, he would say. He will never say that he has encroached upon your land. He would always say that he has raised a construction over his part of the property, and you will say that he has encroached upon your part of property. Where is the basic finding?
Manoj, there is no one.
Then what can I
I'll bow
do?
down to that, Manoj, observation.
Fine, sir. हो गया, sir.
Manoj, may kindly-
No, sir, sorry.
my interest may be taken into consideration.
क्या इंटरेस्ट? आपको पहले भी मैंने दोनों भाषाओं में समझाया. पंजाबी आपको आती नहीं तो उसमें भी समझा देता.
Manoj, may-
उसके बावजूद भी you are sticking to your defense. You know the basic law, sir.
Manoj, I was trying to pursue.
Fine. Once the order was already dictated, then when it was in the midway, you stopped.
Manoj, there
You
was
stop the
optimal-
court.
Manoj,
In the midway, you stopped the court. This is not the way of pursuing the court.
I apologize.
Before starting dictating, I had given you sufficient opportunity. Only once I found कि भाई आपको बस वहीं घूम रहे हो. तो ठीक है.
Manoj, my interest may be taken into
No, sir,
consideration.
sorry. File a civil suit.
Manoj, then in case, Manoj, the evidence is not there.
No, sir.
I am praying, Manoj.
Once there is no finding, I am not going to remand the matter for the third time to such a judge or SDM who doesn't know anything. Do you want any further observation from the court? He had reproduced section 145. He has mentioned that if a person has been dispossessed within 2 months, where is the finding? He is not an ignorant of law. He knows everything. Do you want all these observations? मैंने इतना लिख के छोड़ दिया कि उसको सब पता है, उसके बावजूद उसने सारी चीजें छोड़ी हैं. Do you want that I should draw an inference against such a person?
No, Manoj, I don't.
If a person is aware of the legal provision and the basic ingredients which will give him the jurisdiction, if he is escaping that means he is doing deliberately. And deliberately कौन करवाता है? आप करवाएंगे. और ज्यादा क्लियर बोलूं? और ज्यादा क्लियर बोलूं? It is well established principle of law. मैं इसको फिर से ऐड कर दूं. It is well established principle of law that the civil proceedings should not be converted into a criminal proceedings, and it appears that the respondent has tried to take possession of the property by taking undue advantage of section 145 of proceedings instead of filing a civil suit under section 9 of CPC. I can understand,
Only making.
Mr. Chaudhary, I can understand कि ये जज साहब की आंखें बंद क्यों की गई हैं. ये जज साहब को, मजिस्ट्रेट साहब को नहीं आता, कानून नहीं पता होता. I could have understood. He has mentioned कि भाई ये 2 महीने के अंदर डिस्पोजेशन होना चाहिए. Only then proceedings under section 145 would arise.
Findings the
Why he has deliberately omitted that finding?
findings was not paper, but I can assure there is evidence on record, my lord.
मुझे एक इंप्रेशन आ गया था कि इसकी आंखें बंद करवाई गई हैं, और उसके बाद अभी भी आप चलते ऑर्डर में आप इंटरफियर कर रहे हैं, तो एंजाइटी, ओवर एंजाइटी दिख रही थी।
नहीं, my lord, anxiety नहीं, I was only pursuing, my lord.
चौधरी साहब,
Tenders my apology.
no, चौधरी साहब, first of all tell me, if a magistrate knows that he would assume jurisdiction only if a person is dispossessed within 2 months from the date of the information, then in the next line why he did not to give such finding? What persuaded him not to give such a finding and to pass an order of eviction? मैं इसको थोड़ा सा और फाइन करूंगा सर, अब करने दीजिए मेरे को। आपको ऑर्डर का डिक्टेशन मैंने स्टार्ट किया आफ्टर हैविंग अ डिस्कशन विद यू, आफ्टर गिविंग फुल अपॉर्चुनिटी टू यू, एंड इफ यू पीपल आर गोइंग टू द एक्सटेंट कि हम कोर्ट को ऑर्डर नहीं पास करने देंगे।
नहीं सर, ऐसा नहीं।
ठीक है सर, देखते हैं, आइए आ जाइए सर, फिर नो इशू। इफ यू पीपल आर so adamant that we will not allow the court to pass the order, if you are not satisfied with the order, you have a remedy of filing SLP. इसमें WA नहीं होगी, SLP ही होगी। If you don't want to avail that opportunity, it is your hard luck. I can't say anything, but you cannot resist, you cannot obstruct the court from passing the order, and even in that situation where the court had given you ample opportunity to address. मैंने आपसे कहा था मैं गवाही टच नहीं करूंगा, आप मुझे बस इतनी फाइंडिंग दिखा दीजिए। नहीं थी, मुझे लगा कि टू डू कंप्लीट जस्टिस वापस भेज देते हैं। अदरवाइज राइट फ्रॉम वेरी बिगिनिंग आई हैड एन इंप्रेशन दैट दिस ऑर्डर हैज बीन ऑब्टेन्ड। A magistrate is writing that this is the basic requirement, and in the next line he is skipping that basic requirement and then assuming the powers of a civil court by saying that he has encroached upon, therefore he should vacate it. Is it the duty of the magistrate? मुझे लगा कि चलिए साहब एक बार इनसे और फाइंडिंग ले लेते हैं, तो अब आप चलते ऑर्डर में आप इंटरफेयर कर रहे हैं, अब कर रहे हैं, तो फिर मुझे समझ में आ गया कि मजिस्ट्रेट को भी क्यों नहीं लिखने दिया होगा आप लोगों ने।
नहीं सर, ऐसा नहीं
हो गया सर, फाइल सिविल सूट ना।